essentials, and I also do pension fund law. So this morning, I'm going to talk to you about the legalities of content creation. Legalities just being the legal aspect of what is involved in content creation. For you guys, just to give you an idea what the laws are and how you can protect yourself. So you guys have seen my face. I'm going to switch the camera off and then we'll just go through the slides that we prepared. I think what we're going to do is we're going to start with the intellectual property and then maybe get a few questions in and then go on to contract essentials. Mupulusi, is that fine? Or should we get questions at the end?
I think the best thing is to get the questions at the end.
Okay. All right, that's fine. So I'm going to switch my camera off, ladies and gentlemen, and let's just get into it then. So, like I said this morning, we're going to talk about the legal aspect of content creation. Content creation is it's a new industry. It's not older than about 15 years. So there aren't any specific laws for content creation and content creators. Content creators have to rely on the existing laws, laws that are applicable to the law of contract, media law, intellectual law, labor law, and the law of defamation. So what we're going to focus on today is intellectual property, and then we're also going to look at labor law. So contract essentials are a part of labor law, and I'll explain all of that when we get to that part. So intellectual property basically means what you as an individual have used your mind to create. So these are things that they're called intangible because you can't touch an idea. You can't touch a thought. When somebody creates music, you can't touch the lyrics. So that's why they're called intangible and they are creations of the mind. Mupulusi, can we get the next slide, please? So the law protects the creator of these ideas from unauthorized use by others. So if somebody creates an idea and the next person can't just come along and use that idea as their own because it's protected. And that means that the ideas and the things that you create using your mind can't be used without your permission. So this is what intellectual property means. So it's property that you can't touch and it's created through your intellect. The types of intellectual property are copyright, we've got trademarks, and we've got patents. So with copyright, copyright laws protect songs, books, movies, digital content, videos, photos, and sound recordings. Trademarks protect names, logos, slogans that identify a product or service. So an example of a trademark would be that red and white Coca-Cola sign. Right? You can't just take it and use it as your own. You're going to need permission from Coca-Cola to use their logo. Another example would be those 3 stripes for Adidas. When you see those stripes, you automatically know what brand it is. So that would be trademarks. And then copyright. So for example, you have artists who will use a song sampling an older song. So before they can do that, they need to get permission of the original artist to be able to use the song and then maybe change it a little bit using different lyrics or a different pattern. So all of those original ones are protected. Whoever wants to use it after the author or the original creator needs to get permission. Can we get the next slide, please, Mopulusi? Yeah. So if somebody makes reference to another brand or to their product or to their services, you have to get permission for brand names, logos, products and services, videos, photos created by somebody else. And also, when you think about photos, I'm sure you guys have come across those stock images that have that watermark on it. That means that if somebody else wants to use it, they need to get permission before they can use it, right? So with intellectual property, you have an idea, versus an expression of an idea. So what this means is that an idea is a general concept or a theme underlying a concept which is not protected by law and is in the public domain and can be used. So this is an idea that hasn't been registered. It's in the public domain and anybody can then use that idea. And then you've got an expression of an idea. So an expression of an idea is the specific way that the person, the author, expresses the general concept of a theme. Are you guys with me?
Yes, we
Okay.
yes.
Okay. Yeah. So idea and expression of an idea. An idea is something that already exists. It's in the public domain. Anybody can use it. It's not registered or protected. An expression of idea is a specific way you take that thing that's in the public domain and then you give it your own little tweak or your own little fingerprint and then you put it back in the public, right? Mupulusi, can we have the next slide, please? Okay, so a good example of an idea and an expression of an idea is the saga that happened between Nara Smith and Onezwa. Somebody's raised their hand.
Oh, sorry. It's me. Sorry.
No problem. You can continue with Boitumelo. It's fine.
Oh, okay.
We'll take the questions at the end.
At the end, okay. So are you guys, can I get in the comments just a thumbs up if you guys know about the dispute between Nara Smith and Onezwa? Okay, so basically what happened here is that Nara Smith is a content creator, but she's on the luxury end and she creates these meals and these fancy ball gowns and expensive clothes. And then there's Onezwa. She's a South African creator. I'm not sure if she's based in Natal or the Eastern Cape, but she's from garden to kitchen kind of creator. She's got her own vegetable garden, which she uses for her content creation. And she also makes food. So about, I think it was 2 or 3 weeks ago, she went online and she said that there's a content creator who is stealing her ideas and she's been silent and she actually can't keep quiet anymore because it's not fair. So this is the classic example of the general idea is cooking, content creation, making food, right? And then each one of these ladies takes that idea that's not protected and it's a public idea and they put their own little twist on how they create this content of making food. Can we have the next slide, please? But do you guys remember this lady? Her name is Siba, and she was making food a few years ago. So when you look at Nara Smith, you look at Onezwa, you look at Siba, they all make food. And this is an idea that's in the public domain that anybody can use, and it's not copywritten, it's not registered. So anybody can start a food channel or start some sort of workshop doing cooking, baking, whatever. So even with content creators, with you guys, there are ideas that are in the public domain and you can use it. You just need to give your own unique little twist to it, and then you can run with the idea. So with Nara Smith, apparently she then sent Onezwa a letter of demand saying that you have to retract what you said because it's hurting my brand. So that letter of demand, actually, it's not saying that Onezwa must stop cooking. It's saying that Onezwa must stop saying that Nara stole her ideas because it's affecting her career. And this is called defamation. Defamation is when you put out in the public words or statements that can hurt another person's career or business or livelihood. Okay, are you still with me? All right, okay. Okay, Mupulusi, please can we have the next slide? Okay, so copyright you remember that the earlier slide which talks about copyright and trademarks and patents. The one applicable to content creation is copyright, right? Which protects the original creative work, and it gives the author the exclusive rights to, you can reproduce your work, you can distribute your work wherever you want, you display your work wherever you want, you perform wherever you want, and because it's yours, you then have a right to take it off the internet if you wanted, you wanted off. But this is only for the author or the composer. The author or the composer is the person who actually created this idea. Only they can do that. Anybody else, if they want to reproduce, distribute, display, perform, and remove content, needs to get permission. If you don't get permission, then there are legal consequences, right? And then we go to social media platforms. So Facebook, TikTok, Instagram, LinkedIn doesn't really have it, but they have an intellectual property policy which governs how they deal with intellectual property. So if I come across Mupulusi's posts and I'm just copy and pasting, LinkedIn and those other social medias have a policy as to what they do when somebody breaches their policy to protect the users, right? So can we go to the next slide, please? So we also have something called a music library. So you'll note that on these, and you guys know more about this than me, but on these social media platforms, when you create videos, you're able to give it a soundtrack or use certain lyrics or certain sounds that you can attach to the video and then post it in that manner. So that's called a music library. Those platforms, in accordance with their intellectual property policies, have the rights, have bought the rights or negotiated the rights to use those songs for the users of the platform. So there's music that's available and we are able to use it on the platform without any hassles or breaching any legalities, because the intellectual property policy of that platform has already negotiated for us to use it. Do you guys remember this interview with Drake and Bobby? Okay. So a few months ago, there was an interview. There was an interview with this lady Bobby, who's blown up overnight, literally, and Drake. And the interview was said to be her most popular because the views were insane. I think she was in the millions, and it was her best podcast ever. She did really, really, really well. So I don't know what happened between her and Drake, but during the interview, Drake then played a song by Tiger, Rack City, on his phone, and he left it playing through the duration of the interview, right? Apparently, Drake then had a fallout with this lady, or he didn't like the interview, but something went pear-shaped, something went really bad. His people then alerted the owners of that track, which I think is Universal Music, that this episode was playing music without being authorized to play that music by Universal or the company that was holding the rights. Bobby then she wasn't forced. She then decided to take this podcast down because there was music playing in the background that she wasn't authorized to use. And if she had left it on YouTube on the internet, the owners of the music would be entitled to sue her for the proceeds of whatever viewership she got from that YouTube podcast. So she decided to take it down because she didn't want to deal with the implications and the legalities of using music that wasn't in the music library and that had not been authorized. So if it's not authorized, you need to be very careful that whatever it is that you put out is authorized, because the owners, the authors, the creators are then entitled to say, you are using my intellectual property without proper authorization, and I then am allowed to take action against you to either sue, demand that you remove it from the internet, demand that it's scrubbed, whatever it is that they feel is the correct process or the correct steps for them to take in order to right the wrong that you have done. So before using anything that hasn't been put into the music library, just make sure that the authorization has been obtained and that you are legally allowed to then use that the music or the sound or the images, whatever it is that you intend to use. The other aspect is that there's a lot of AI websites and creators. If content creators are working with these websites or these creators, then content creators are obliged to give these creators credit. So if they're parts of whatever it is that you're doing and you have input from AI, then that AI has to be credited somewhere in your creation, on the video, on the sound, whatever it is. It needs to be credited so that it doesn't look like you did this on your own, because you didn't do it on your own. You had help from a website or a creator or AI device. Okay. So that's it on intellectual property, and then we're going to move into contract essentials. Okay, so contract essentials, ladies and gentlemen, is a part of labor law, right? So labor law is the law that regulates employers and employees and independent contractors and part-time workers. So any employment relationship ideally is not ideally, every employment relationship is regulated by labor law, and the relationship between employer and employee ideally must be regulated by an employment contract, right? So an employment contract is a document, an agreement between two or more parties. The one party will be the content creator, the other party will be the employer, right? The contract must set out the services or the goods that are being given. It must set out the scope of the services or the goods, right? So each party to the contract, if there are two people, both people have obligations towards each other. If there are four people, then all four people have obligations towards each other. The contract is for a specific period of time. It will be a 24-month contract, or it could be a 3-month contract, or an 11-month contract. Or they could say, we need 100 hours from you. So it has to be for a specific period of time and for a fee. So you must agree on a fee for your services. You know, there's some people who, and I hope you guys don't do this, some people who will perform a task and then they say, ah, you see how much you pay me. That shouldn't be how you conduct your agreements. So there should be a specific fee and then also a termination. So termination is the clause that says when XY happens, then the agreement will be terminated. Once I deliver this project, then the agreement is terminated. Once the show is over, whatever it is, there needs to be a termination clause in the contract between you and the person that you are rendering services to, right? The actual agreement, it must include the registered address of the party that you're working with. So registered address is the address where they accept all legal documents. So you find some people will work from home, but in terms of the CIPC records, they have a registered address in Parktown. So that's the address where all legal documents are delivered. And this is important because if there is a dispute between the parties and you have to send a letter of demand or you have to issue summons, this is the address that you're going to use. And if they say, no, I never received it, then it doesn't matter because this is the address which they are telling the public that if you need to give me any document, drop it off at this place and I will get it. Okay, so it's very important to know where these people that you are dealing with, where are they based, where they're situated. It's also important to realize that when you are dealing with another party and you enter into an agreement, that person that you are discussing the agreement with and who's actually signing the agreement is authorized to enter into that agreement. So for example, if I say, Mupulusi, I need your services, and then she says, I've got a document, I need you to sign it. If I get the lady who helps us with the tea or the lady who helps us with the cleaning in the office to sign that agreement, she's not authorized to enter into an agreement. So Mupulusi is going to have a document that's signed by her and it's signed by somebody who doesn't have the power to enter into an agreement. If Mupulusi turns around and says, you haven't paid, now I'm going to sue you, I then turn around and say, no, this document was signed by the wrong person. So if you want to sue, go ahead. But all I'm going to say is that this person wasn't authorized to enter an agreement on my behalf. Therefore, it's not valid. So always make sure that the person that you are negotiating with and the person that signs your documents is actually authorized to enter into those agreements. Because then you just have a useless piece of paper with signatures that don't actually mean anything. It's also important for you to get this contract in writing. In writing, because it's easier to prove things that are on paper. It's very hard to prove a telephone discussion. It's hard to prove a discussion, an agreement that you entered into with somebody at the coffee shop. It's hard to prove a discussion that you had while you guys were running a marathon. Get your documents in writing. Get your documents in writing so that if there's anything that you don't agree with, it's in black and white, you are able to change it. Make sure your documents are signed. A signature is somebody saying, I agree to what is in this document. Get your documents, all of them, in writing and get them signed. It's easier to prove a written document, number one. Number two, when there's a dispute with a contract, the court takes the document, the paper as it is, as the sole evidence of what the dispute is about. So you find people who write a document, an agreement, they sign it. 2 days later, they have a conversation and the one person says, oh, you know what? I actually need all of this content to be put on TikTok. How much is that going to cost? You then give them a price. They say, yeah, that's fine. And then you do the work and then they don't pay you for that. And your problem is going to be that you didn't do an addendum. An addendum is an additional piece of paper where you say, we signed the contract on the 1st of July. On the 4th of July, we had a phone call and we agreed to do additional work for TikTok. And here's the addendum. And then you attach it and then you sign it again. So you're going to have an agreement that has 2 signatures. The first signature is from 1 July. The second signature is from 4 July. Because if you don't do that second signature for July, the court is going to say, well, what proof is there? How do you prove that this additional work was actually asked for and that these people said they were going to pay you however much? You don't. You just have a telephone call in your memory. Get everything in writing, guys. Get it in writing and get it signed. It takes, when your documents are in writing and signed, it takes about 40% of the stress away. And sometimes when people are not as honest as they should be, once you give them a signed document that they signed, then they sort of tend to back off and they give you what you want because they can actually see that it means I have to fight and I can't really fight because I've agreed to this. But if there's nothing there, he's like, well, go ahead and see what you can prove. And remember, court is expensive, attorneys are expensive, upping and downing court dates, it takes your time where you could be making money, you're now actually spending money. So make an effort to get your documents in writing and get them signed. And then obviously it goes without saying, you need a proper storage system for all of your documents. You need to learn to save your documents properly, because unfortunately with these sort of things, the dispute always comes up 4 or 5, 6 years later, when you actually really can't even remember what is what, where it was. So make sure you learn how to save your documents properly, so that if you do need them in future, you know where to find them. Okay. The agreement must also have a payment date. So you're going to say on the 1st of every month or on the 15th of every month, payment is going to be made into this account. Default is the clause that says, what do we do if they don't pay you on time? They don't give you what you need to be able to complete your task. So for example, if you are doing work that needs you to be able to access, I don't know, you guys can give me an example. Maybe you need to access your client's workspace, or you need to be there when they are doing events so you can get content, all of that. And then they don't invite you to these things, so you don't have the content. Then that's a default, because essentially they are blocking you from being able to do what they want you to do. So you have to have a clause that says, you will invite me to all of your events, you will pay for my transport, I will be there for 4 hours, and then you will allow me to capture images, videos, whatever, for the content for this client. If you don't do that, then you can't blame me. If I send you an email and I say, I'm ready, well, I agreed to come to your event on Saturday the 17th, and then you don't give me any details, you can't then turn around and say, I'm not doing my job, because you're the one who didn't give me the time, the place, how to get there, all of that. So you need a default clause. You also need then a cancellation clause. A cancellation clause is where they are not enabling you to do what you're supposed to do in terms of the agreement. They maybe give you late instructions. They tell you on Thursday that this project is actually due for Friday morning. It's not enough time, and you want to cancel, or they don't pay you, or they don't pay you on time, or whatever it is that might lead to a cancellation. You need a clause in there that says, if you do this and I give you time to fix it and you don't fix it, then I will cancel within 14 working days. And there's nothing that you can do. You can't sue me for breach or anything. And then the same applies for them. So if you have a client, but you are always late, your work is always late, the work is not up to standard, then they can turn around and say, look, we're not happy with what you're doing. Please fix it. If it's not fixed within 7 days or 5 days, then we're going to cancel this agreement, and then give you an opportunity to fix the work. The last one that we have to look at is enforcement. Enforcement is when you actually now people start suing each other to enforce the terms of the agreement. Sometimes people enforce payment that hasn't been made. Sometimes people get paid an amount that's not the full amount, and then they want an enforcement of the balance due to them. Sometimes people want to force a client to actually keep them on and let them do the work. So if a client wants to, if you get a client and they say, look, we want to do content for, I don't know, the most exciting brand at the moment, I don't know which one that is, and this is going to be actually a good thing for your portfolio, your experience, and then suddenly the client doesn't want to work with you anymore, then you can say, no, we signed this agreement, and if needs be, I'm going to take you to court so that I can actually work on this project and finish it. So sometimes the enforcement is for you to carry on working. So there are various aspects of enforcement where somebody was supposed to do something and they didn't do it, and now you want them to do it, or you actually don't want to work with them anymore. You want to cancel, so you cancel and you get your fees paid. So those are the contract essentials, right? With content creators, you guys are not employees. You are independent contractors. So your agreements with your clients or whoever is giving you work, it's going to be for a specific period of time. It's going to be for a specific fee. There's going to be a scope of the services that you are supposed to render. You have obligations. they have obligations, and then there should be a termination. And your agreement must include all of these bullet points on the right-hand side. Some people will try to get you to work without an agreement. If they bully you, or they intimidate you, or they dragging their feet, the next best thing is for you to confirm everything on email. So you'll send an email and say, hi, so-and-so, on such and such a date, we had a meeting, we agreed to the following, and then you list it in bullet points. And then you say, please confirm that this is still what you need. Please, can you also confirm that the fee is X? I will try and do the work within a period of X, and I will deliver it to you, and then you can make payment. Hopefully they come back to you and they say, yeah, everything in your email is correct, proceed. In the absence of a contract, at least you've got an email setting out what you were supposed to do and what they were supposed to do. But the first prize is a contract always. So always, always, always try to get a contract, always. And if you do your best and these people aren't cooperating, maybe they're not the type of people you want to work with. You really, really want to work with them, just get something on email. So independent contractors, you're not entitled to benefits like medical aid, sick leave, the benefits that a permanent employee would be given. Independent contractors aren't given, because it's assumed that the working relationship is only for a certain period of time. And usually it's not long periods of time, it's just a few weeks or a few months. Yeah. I don't know if any of you guys are doing work with international companies, where international brands, where the laws will be different. So these contract laws are South African laws. But if you're dealing with a company that's in Botswana or maybe Namibia, Swaziland, the laws are going to be slightly different, because the laws of that country will then be applicable. And the challenge with that, it's not a problem, it's a challenge, is that if there is non-payment, then what do you do? Because going to a different country to litigate is extremely expensive. So sometimes asking for a deposit, or doing your work in tranches. So you do part A, you get paid, you do part B, you get paid, you do part C, you get paid, instead of waiting for your payment at the end of the project. Sometimes that helps, because you don't want to now be working and then not getting paid and not even having the resources to recover your funds. So when you are doing work for international companies and brands, just be alert to the laws that would be applicable, and try and find ways where you're not waiting for your lump sum at the end, that you are at least getting some funds throughout the duration of the work that you're supposed to do. Okay, so that's the end of the presentation. I'm happy to take questions if you have.
Thank you, Boitumelo. That was very insightful. We can have 20 minutes for questions. We only have 20 minutes left. Yes.
Okay.
So we can get started with the questions now.
Virtual Africa has raised his hand.
Hi. Sorry, I'm using my company Google Meet instead of my personal one. Collabora. I have a question regarding the international, like working with international clients or whatnot. Would both laws of the country cover the contract? Which one would be like the law that would be assigned to the contract at that time?
Well, this would be a discussion between the parties, but people tend to make it easier for themselves. So if you have somebody who's in Botswana, they'll probably put in the contract that the laws of Botswana are applicable, and then you would have to go there to litigate. So the person who drafts it will probably usually put in whatever's convenient for them. So if you draft it, then you'll say South African laws are applicable. And then they'll come back and try and negotiate. You say yes, no, but there's no hard and fast rule cast in stone saying this is going to be the applicable law. Whoever drafts it, remember the person who drafts the contract is going to make it as favorable to them as possible. And then it's, the obligation is on you to come back and say, no, this doesn't work for me. Can we change it and make it this? This actually doesn't work for me. So for example, for a fee, you will decide, I think the Pula is stronger than the Rand. So you might say, look, I'm happy to receive payment in Pula, but if there's a dispute, we're going to have it in South Africa.
Okay.
Yeah. So it's something that's negotiated, but you need to be awake to that so that if they put it in, you can say, no, it doesn't work for me. We would rather be in South Africa than in Botswana.
Okay. And then my second question, do all South African contracts, are they all governed by the South African contract law, or is it dependable on the situation or something like that?
Yeah, all of them are. Remember, so all contracts, all of them are governed by contract law. All of them. So it's going to be employment agreements. Remember, if you have a pension fund or retirement annuity, all of those laws are governed by the contracts of pension. So you still have, it's between you and Momentum. You give them money every month so that they can give you protection. So all across the board. Always. Yeah.
Okay. Well, thank you. Those are my questions.
Okay.
All right, we have Kumoto who just raised their hand. Kumoto, you can ask your question.
Hi guys, how are you?
Fine, thank you. How are you?
I'm good. I just want to understand on the content creators. For example, the content creator and also receiving client. Because okay, as an IT person, right, I normally receive clients who bring clients, but at the end of the day, they are failing to pay the fees that they have charged them.
Sorry, Khomoto, please speak up. I can't hear you properly. I just heard that you're in IT.
Okay, let me just repeat what he said. Okay, he said that he's working for IT, and sometimes the clients that he has, they delay with payments. How do you approach that?
Oh. So the best way to approach that, do you have agreements in place with them where you agree which date they're going to pay you on?
We do have an agreement, but when that agreement reaches another stage.
Yeah. So the best thing to do is you have an agreement in place, and then when you send your invoices, try to send your invoices with enough. So if, let's just say your payment date is the 25th, try to send your invoices before the 10th, and then phone them on the 10th to tell them that you've sent your invoices, phone them again on the 15th, and then on the 20th. The thing is, Khomoto, when you start suing people, the relationship breaks down. So if you sue these clients, you're probably never going to work with them again. So the best thing to do is communicate with them and just tell them that this is affecting your business negatively because payments are always late. And then you're going to have to decide, or your company is going to have to decide if you want to continue with them or not. Or what you can do is enter into another agreement and say, look, we need the payment before we start any work. That might help.
Understood. Thank you.
Yeah. Okay.
And we have Vusi who also raised his hand. Vusi, you can ask your question.
Yes, I do have a question. Can you guys hear me?
Yes, we can hear you.
I've got, I think it's a two-part question. Number one, do the legal fees then of like drafting a contract, should they be included in the invoice that you send to the client or not?
Well, if you're getting somebody who's gonna draft the agreement, then you can try and put it in, but it's not for the other party. It's not an expense for the other party. It's actually your expense. So, for example, if I was entering into an agreement with somebody and they gave me an agreement and they've said that we're going to draft a contract and you must pay for it, I would say no. So what you
Okay.
can do is, let's just say your fee is, for example, 5,000 Rand. Then maybe you should say your fee is 6.5, and then take that 1.5 and pay whoever's drafting. But you can't then make the other party liable for drafting an agreement.
Okay. Then is there a danger then in using templates that are available online just to try to avoid obviously that kind of discussion where I need to put the legal fees or the drafting of the contract in the invoice? What are the
So,
dangers?
so a template is basically it's a standard agreement. It doesn't take into account what you guys have agreed on. It doesn't take into account anything that you don't want. There's a lot it doesn't take into account. So if you have a very straightforward agreement with your client, I'm talking simple. You need XYZ. I'm going to pay you XYZ on such and such a date. If it is extremely simple and there's nothing to it, then you can use a template. But I never encourage people to use templates, because when you agree, there are a lot of things that the template does not include. So it may be that there's something that needs to be in there and the template doesn't have it. And then because it's not in the template, then it's not included, and it's something that's missing that should be there. But like I said, if you have the simplest, most simple agreement, like I don't even know what example to use. If somebody comes to you and says, please make me 3 slides, I'm gonna pay you 500 Rand. And that's it, there's nothing else, then you can use a template. But if somebody's saying, here's a brief, I need the first draft, I need you to do Facebook, Instagram, LinkedIn, I need analytics, I want to see who's looking at this, then you need don't use a template, because there's going to be a lot of stuff that should be in there that's not in there.
All right. Thank you very much.
Okay.
All right. We have Mahmoud Tabo. I hope I said your name right. Who also raised their hand.
Hi, Mamu Chabo.
Hi, how are you?
I'm well, thank you. How are you?
I'm all right. I have a question here. So, they just asked about using a template, but I can customize it, right? Like add those elements that are not in the template, right?
Yes, you can, if you know how to draft legal documents.
Okay. And since you mentioned including the registered address, so let's just say I'm starting out and I just want to test out this business, and I don't want to register yet. Can I include like the SARS registration address maybe?
Yeah, you can. Yes, you can. Remember, I'm speaking to you guys so that you guys know what you should be doing. So if you haven't registered yet and you want to include a SARS address, that's fine. But if you're going to be working with Samsung, then you need to, if Samsung doesn't pay you, then you need to be able to find them. If you're going to be working with Batu or whoever else, guys, I'm sure there are lots of brands that I'm not aware of, but if you are working with the brand and they don't pay you, you need to be able to find them so that you can get your money. Whether you are registered or not, you should be registered and you should have a registered address. If they want to come find you, they've got the resources and the money to look for you and find you and say, look, you owe us work, or this is what we want from you. But I'm looking at it from what you guys need. So whether you are registered or not, you should be, but it's not a train smash. But the person that you are working with, we want to be able to find them if we need them. You know, if there's any payment or if there's whatever you need from them, we want you to be able to find them. That's why I had included the registered address, because some people enter into agreements and then it takes them 4, 5, 6 months and they still can't find this person. And in trying to locate the other party, it costs money.
So I
Sis.
shouldn't. Sorry. Yeah, you were still saying.
Yeah, so I think my approach is just for you guys to have information to protect yourselves, that if you are entering into agreements and somebody's like, don't worry, you can find me at this corner every Saturday, that's not good enough. So you should also just sort yourself out, but it's not extremely urgent, or but it just looks more professional where you have a proper registered address. And if you want, your registered address could be your home. It could be where you live. Doesn't have to be a business or an office park or anything. It could just be where you live.
So I should include my address and the client's address as well.
Yes.
All right. Thank you very much.
Okay.
All right. I think this one is quite an important one for most of us, contracts. And I wish we had like a template that we were able to see on how to draft one. But that's a story for another day. Maybe she can do another webinar with us again, depending on her availability. So we only have like 5 minutes. I have Denzel and I also have Veronica who wants to ask a question. Denzel, you can go.
Hi guys, can you guys hear me?
Yes.
Okay. So my question, because most of this advice we get from like fellow American freelancers, and I wish like more lawyers like you could tap into the space where we get advice. So my question is on legalese when you're like drafting out a contract, because when you listen to like Americans, they tell you like you can even write in plain language as long the other person signs, it's a binding contract. So my question is, does it really have to be legalese, or it just has to be like in plain, especially if the agreement, the project is not complex, can it be written like in plain language? Because there's the other guy was asking about payments. I usually just put in my contract that if you delay by a day, that's 10% of the whole invoice per single day. I don't know. So that's the second question. I don't know if that kind of a clause is applicable with South African contract law, or it's a bit, I don't know. Maybe you can share light on that. Thank you so much.
Okay. So attorneys like sounding important and clever, and that's why we use these bombastic and combobulated words so that we sound educated and smart. But there's now like a new trend where simple language is the way to go. It doesn't make sense to be drafting these documents with these huge words that only you and the other attorney understand and your client doesn't understand. So plain language is the way to go. Make it as simple and as concise and understandable as possible. So the answer to your first question is, yeah, it should be in plain language. You don't need to use Latin or these big words. Just make sure that you're drafting an agreement that everybody can understand. The second part of your question is whether you can put in interest on late payment. Yes, you can. So you can put in late payment penalty interest. You can make it by day, you can make it by week. You find some people who'll say, my fee for this project is 9,000 Rand, but if you pay me on or before whatever date, I'm happy to charge you 8,500 Rand. So you are able to vary the payment terms. You can put your price up, you can put your price down. Remember, a contract is an agreement. So the biggest part is for you and the person that you are contracting with to agree. So if you want to charge however much and I say, I can't afford that, I want to work with you, I can't afford that, please reduce your price to 6.9 and you say, okay, then we have an agreement, it's a contract. So you are entitled to do that. And you're 100% right. Like I said, social media isn't a very established or long established career path. So I think the South African landscape is slowly catching up, but we're not as advanced as the Americans or the British and other jurisdictions where it comes to social media and the laws and what should be done and what shouldn't be done. You're 100% right. That there should be more of us, and maybe that's something I need to look into, offering that kind of service. But they're not a lot of people who do that type of law.
Awesome. We have Veronica. Veronica, you can pick to ask a question. I'm not sure if Virtual Africa still wants to ask something, because I do see her hand up.
Yeah, I do, but I'll ask after
Hello.
one.
Hi guys, am I audible? Can you hear me?
Yes, Vero.
Yes.
Okay, my question is about tax. So I wanted to know what tax obligations do freelancers need to be aware of, and how can we show compliance with tax laws?
Okay, so tax is a bit complicated. As a freelancer, the obligation is on you to pay the tax that is due, and the tax that is due is determined by the amount that you're invoicing. So I don't know what you call it, but every instruction or every project you work in will have a tax element, and it depends on how much it is. There are some people who have their businesses, freelancers who then register their businesses as VAT vendors or not VAT vendors. So that is going to need specific attention to whatever it is that particular freelancer is doing to be able to calculate the VAT, and then also other compliance with SARS, which would be due on an annual basis. But that's very individual to each person, because I think you guys do different types of projects and you charge different types of rates and all of that. So when you want to get tax compliant, you would the cheapest thing is to actually phone SARS and have somebody to explain what your particular obligations are. Alternatively, you could consult with an attorney, but I think speaking to a SARS consultant directly is much cheaper. Well, it's free, except for for your airtime. It's probably free. So that, Veronica, you would then need to speak to SARS specifically for the work that you've done over the past 12 months to be able to calculate your obligations.
Okay. So I hope everyone is answered, and we have Virtual Africa who wants to ask another question.
Yeah, sorry, just the final question. When it comes to drafting contracts, do you have to be of a specific authority, or as long as it's an agreement that both you and the other party understand, or does it have to be a professional that actually drafts it?
No, you can draft it just as long as it has everything that you guys have agreed on, and you are over the age of 18, because anybody under the age of 18 is not allowed to legally bind themselves or anybody else. So if we have like my niece who's 15, if she decides to start a company, all of her agreements are going to need to be signed by either her mom, her dad, or somebody who's over the age of 18. So just make sure you're over 18 and you understand what you're agreeing to. Anybody can draft a simple agreement and get it signed.
Okay, cool. Thank you.
Okay.
That was a great question. I actually thought only expect needs to draft a contract. And my question is, what do you think about drafting a question using ChatGPT? I actually do that. What do you think?
I think if, like I said, if it's a very simple agreement, then ChatGPT is okay. The problem comes in when it gets more complex, and there are things like a Visma year. Remember with COVID, a lot of agreements weren't able to be fulfilled because there was this situation, intervening situation where people were homebound. And if you are in construction, then you need to make some sort of other plan as to how are you going to fulfill your obligations. So if it's a very simple agreement, Mupulusi, go for it. But if it's you now needing to be getting content from Bloemfontein, and then you need more content from Durban, and then you need to put it together by X date, and there are penalties if you don't, then I would suggest that you actually consult with an attorney to be able to make sure that your rights are protected. If anything goes wrong, then you are protected, you know. If you, and also there's a difference between an agreement, let's say a contract for 5,000 Rand and a contract for 500,000 Rand. If the value is 500,000 Rand, it's not going to be 2 lines. It's going to be more involved, and there are going to be more implications and more attention to detail. So I wouldn't use AI for the 500,000 agreement. The 5,000 one, yeah, I would. I'd be like, yeah, it's okay. So the more complicated and more involved it is, don't use AI. The more onerous your obligation, don't use AI. If you're dealing with I was about to say opponent. If you're dealing with a client who's got a bigger budget than you and has bigger footprint, and they are sort of able to bully you if they need to, don't use AI. Just get an attorney and make sure that everything is above board, so that if things do go wrong, then at least you're properly protected and you're able to fight if you need to fight.
Thank you so much. It makes clear sense. If you know that you've got nothing to lose on that 500 or 5,000 project, it means we could just draft our own contract. But I have
Yes.
one last question before Mamu Chabo asks her last question. What are the prices of maybe experts really drafting our contracts? Do you know an estimate price of, if we need to pay someone to really draft our contract, how much are we going to pay for that?
It depends on who you get to draft your contract. So the more senior attorney, so if an attorney's been in practice for like 15 years or so, they normally charge in the range of about 2,500. If you get somebody who's been in practice for about 5-6 years, they'll probably charge you about 1.8, 1.9. But negotiate. So when you get an attorney that you actually want to work with, just negotiate and tell them, look, I need this thing done. I really want to work with you. I don't have 15,000 Rand for legal, but I've got however much, 2,000 Rand. And the thing about that is that if you sort of do the same type of content, you're able to use that same agreement over and over again using the same attorney. And then you tweak what needs to be tweaked. So for example, let's say you do something with a South African brand, you get that agreement, and then you get a brand from Zim. And now maybe the issues of payment, you're going to get paid in dollars instead of rands, and a few other things need to be tweaked. You go to that same attorney and say, look, you helped me with this, and now I need just a few minor changes. Don't charge me the full amount. Just charge me a fraction, because we're not changing the whole thing, just a few things. So that will work out cheaper. They might let you do it maybe 3 or 4 times. After that, they're going to like charge you to draft a new one. But get somebody who, try find somebody who you're able to build a long-term relationship with, who'll be able to advise you on a regular basis, draft your documents and give you advice where you need it. But I would go for somebody who hasn't been in practice for too long, because they come slightly cheaper.
Thank you so much. Okay, I hope this is our last question, because time is running. It's 1:07 now. So, Mamu Chavo, you can ask your last question, please.
Okay, so if I want to register to pay SARS, I have an agency and I outsource my services. I hire freelancers to render the services. So, what do I register as? I didn't register my business. I mentioned that I don't want to register it yet. What do I register as on SARS?
So you've got a business, but you outsource everything.
Yes.
Okay, well, there are different types of companies. I get it. You've got a sole proprietor, you've got an incorporated, you've got a no, you won't be a PTY Ltd. What type of work do you do?
Social media marketing, basically digital. It's a digital marketing agency.
Yeah. And how long have you been running this for without it being registered?
I'm just starting.
Oh, just starting like January or like 2 weeks ago.
Generally, I haven't even looked for clients yet. I was just looking for
No.
freelancers, and I just want to compile information before I take action.
Yeah, no. I think remember you start with the registration at CIPC, right? And then once you have the registration at CIPC, then SARS comes into play. The reason being, if you've registered a company and it's dormant, like you don't do any work, then SARS isn't going to say pay us because you haven't been making money. So if you register a company in 2016 and then you actually only start working in 2019, between 2016 and 2019, SARS is not going to be an issue for you because you haven't been making money. SARS is for money. Your tax. So if you make like 40K a month, then they're probably going to take like 6K or so. But if you're making like nothing, then there's nothing to take. So before you start worrying about SARS, you need to register with CIPC first, make money, and then SARS will then come into play where you have to register as a taxpayer.
So now I'm obligated to register at SARS.
No, you're not.
I mean at thingy CIPC.
Well, you're not obligated. If you want to carry on for a little bit without being registered, then there's nothing stopping you. But remember, SARS is gonna your bank account, if your bank account starts looking healthy, then SARS is gonna come find you.
Yes, so right now, like hence I'm saying, can I just register for SARS in case I make millions?
Before, but what I'm saying is, yes, you can, but you need, if you want a registered company, an entity, you need to start also at CIPC, right? Because you're going to have a company registration number, and that's the entity that SARS is going to be dealing with. When SARS communicates with you, then they're going to quote that registration number of your company.
So can I like? Oh, sorry,
I'm listening.
Can't I register like as an individual?
You can.
Okay. Then it's time I register at CIPC, then maybe update my information.
Yeah, but you're doing it backwards. But you can. There's nothing stopping you, but you're doing it backwards, but you can. Look, if you've just started, I think don't be too stressed about SARS. Honestly, if you've just started and you're not making that like a taxable income, then don't stress yet. Just have it in the back of your mind that maybe next year this time you need to do it.
Okay, because I just wanted to register like, beforehand. And then when I start making amounts that fall under any tax bracket, then I will know what I have to.
Yeah. You see, that's the financial side of the business, and I think you guys will need somebody who will address that financial side about tax brackets, and if you earn between X and Y, this is your tax liability, the company tax liability. As an employee of your company, then you are paying yourself a salary of however much. The company's tax liability is this much, your tax liability is that much. If you have freelancers, then you don't pay their tax, they pay it themselves from whatever you pay them as a fee for the work they've done. So the financial side also needs attention, but that's not my forte. My forte is the legal.
Okay.
Yes. I'm sorry, Ma'am Thabo. We will then have to get someone who is an expert regarding that topic, but I'll take note of that.
Yeah.
But I could also advise that if you are just starting, you can just reserve your business name for now on CIPC. Meaning you're not even registering your business because you're not even sure if you're going to make that money. Then once you are ready, once you see that your business is growing, then you can move forward with registering the business, dealing with the tax issues and all that. So yeah, that's my advice. I guess that's the end of it. Thank you so much, Boitumelo. This has been amazing. I know we cannot end right now. There's so many questions. There's so many things that a lot of business owners, freelancers are dealing with. And once we have that opportunity with you again, I will still communicate on when is our next webinar with you. But I really appreciate your time and thank you for everyone who has joined this webinar and have learned a lot from it. I hope you do well. I hope you took notes, and if you're going to draft your contract, you can see those are the important essentials that you need to have on your contract. So that's it from us. Boitumelo, do you want to say anything regarding your business? How do people get hold of you? And if there's any details we need to know more about you?
Well, thank you very much for your time, guys, for coming through for the session. My details, I'm on LinkedIn, I'm on Facebook, and I was on Instagram. I haven't been active for a few months, but it's Boitumelo Monyatsi on LinkedIn and Facebook. BM, there we go. Thank you, Mupulusi. There we go. Those are the contact details, guys. And you can find me, like I said, on LinkedIn, Facebook, and Instagram. Thank you so much. I will, well, depending on the demand, we'll do another one where there are proper templates and we can go through it in proper detail so you guys get more information. And also, if there's anything else that you would like to know, please let Mopulusi know so that we can touch on it on the next. Thank you, Erasmus, so that we can touch on it at the next webinar. But thank you very much, guys. I hope you found it useful and helpful. And have a good Thursday. Thank you, Mopulusi.
Thank you, guys.
Bye.
Thank you, Bye-bye.